I request seated. We'll start the program very soon. Fragrances have filled the air, for with your arrival today, this gathering has become beautifully adorned. Let me also dedicate one couplet for Mr. Tarkunde, in whose memory we are hosting this 16th Tarkunde Memorial Lecture. अदल की राह में जो चला था बेखौफ बेबाक, वो वकील आज भी दिलों में जगा रहा है चराग. The one who strode the road of justice, fearless and unafraid, the lawyer still kindles a glowing lamp in every heart. I welcome all of you on behalf of the President, our President, Mr. Justice Madan Lokur, our Vice President, Mr. Raju Ramachandran, and our Secretary, Mrs. Manik Karanjawala, and also the members of Tarkunde Memorial Foundation for the 16th Tarkunde Memorial Lecture, which is being delivered today by Honorable Mr. Justice Abhay Srinivas Oak, former Judge of the Supreme Court of India. The topic chosen by His Lordship is our Constitution and the fundamental duty to develop a scientific temper. I now have a very pleasant duty to perform. I will now request Mr. Ashok Panda, Senior Advocate, to present a bouquet to our Chief Guest, Honorable Mr. Justice Abhay Srinivas Oak, former Judge, Supreme Court of India. Thank you, sir. I now request Mr. N.D. Pancholi, who also had a long association with Mr. V.M. Tarkunde, to give a bouquet to our President, Honorable Mr. Justice Madan Bhimrao Lokur. I will now request Mrs. Tahira Karanjawala, granddaughter of late Mr. Tarkunde, to give a bouquet to our Vice President, Mr. Raju Ramachandran. I now invite Mr. Raju Ramachandran, our Vice President, who will speak about late Mr. Tarkunde and also briefly introduce our speaker, Mr. Raju Ramachandran.
Good evening. Welcome to this, our 16th memorial lecture. It was in 1973. I had just enrolled as a law student. That was the year judges had been superseded after the Keshavananda Bharati case. That is when I first heard of and heard Vitthal Mahadev Tarkunde. He, being a prominent person already in the public life of the country after retirement, early retirement as a judge of the Bombay High Court, was vocal against the supersession of judges. And I realized the towering stature he carried in the legal fraternity. Tarkunde's career was dedicated to fighting for justice, fairness, and equality. He co-founded the group Citizens for Democracy with Jayaprakash Narayan in 1974, serving as its General Secretary and later its President. He was also a founding member of the People's Union for Civil Liberties and Democratic Rights. Even in his student years, he displayed a desire to engage with public life. He was a brilliant student. He could have chosen to study anything, but he chose agriculture because he believed that in order to develop a strong understanding of India and its economy, one had to understand its foundation. I must also tell you that in 49 and a half years of practice, I've come across only one other lawyer who has done a BSc in agriculture, and that is one Mr. Naveen Kumar, who's a leading mining lawyer. So I always tell him that you and Tarkunde are of the same skin. He went to London to qualify as a barrister, but he did not limit himself to the law. He attended lectures in economics, political science, and social anthropology at the London School of Economics. When he returned to India after studies in 1933, he began practicing law in Pune, but simultaneously joined the Congress Socialist Party and worked in villages for political and social awakening. The pursuit of both legal practice and social work was to continue throughout his life. He married Dwaraka, later Chitra Valimbe, in 1940. She became his comrade in arms, involved in every aspect of his social and political work. His political philosophy evolved when he met M.N. Roy, who became his mentor. Roy had evolved the philosophy of radical humanism, and Tarkunde subscribed and imbibed that philosophy. He even quit his legal practice for 6 long years to work for the party which M.N. Roy had founded. When he returned to practice, his practice was not a fashionable practice because he took up the cases of the underprivileged, the working classes. So I understand from Manik that it wasn't an easy or luxurious life which he led as a lawyer. And even later, as a leading Supreme Court lawyer also, he was very modest in his lifestyle because with the greater earnings as a leading Supreme Court lawyer, he was contributing much to worthy causes. The story of how Tarkunde became a judge is very interesting, especially today when we have this debate about judges having political views. Chief Justice Chagla invited him to be a judge, and objections were raised about his political past. Chagla put his foot down and ensured his appointment, taking the view that a lawyer without political beliefs was not worth his salt. But as a judge, he was free of his political affiliations. He was bold and independent. And therefore, because he was bold and independent and fiercely independent, he wasn't such a popular judge. During the emergency, Tarkunde was at the forefront of defending civil liberties and democratic rights in the courts and outside. One of the notable cases in which he appeared was the habeas corpus petition filed on behalf of the well-known journalist Kuldeep Nayyar. Tarkunde convinced the Delhi High Court to rule in favor of his release, and that was perhaps an early instance of punitive transfer of judges, because there were two brave judges who insisted on giving the judgment, though the government had tried to preempt the judgment by releasing Kuldeep Nayyar. They said, no, we will proceed to judgment. One of the judges, S. Rangarajan, was transferred to Guwahati, and the other judge, R. N. Agarwal, reverted as district and sessions judge of Delhi. I briefed him in many cases as a young lawyer. I was deeply impressed with his hard work. He always strove to put forth his best, regardless of how convinced he was of his client's case. Tarkunde also defended the right to practice one's religion without discrimination. He was himself, of course, an atheist, appearing for Muslim parties seeking exemption from anti-slaughter laws to celebrate Bakrid, as well as for Anand Margis, who wanted to carry out a procession with daggers, trishuls and skulls. He was active in exposing human rights violations against the Sikh community and even against alleged Naxalites. To counter the menace of communalism and potential establishment of a theocratic state in the wake of the demolition of the Babri Masjid, he became president of the Forum for Democracy and Communal Amity. But such was his eminence and standing in public life that one of the first actions of the NDA-1 government, headed by Atal Bihari Vajpayee, was to award him the Padma Bhushan in April 1998. A few words about our distinguished speaker this evening, Justice Oak, who in his own work has honored the legacy of V.M. Tarkunde. He has practiced the ideals for which Tarkunde fought: integrity, independence, and the courage to hold power to account for its actions. He served in the Supreme Court from August 21 to May 25. Much like Tarkunde, he was a bold, forthright, and fiercely independent judge who unhesitatingly endeavored to find a just outcome in the cases before him. We expect our judges to be guardians of the Constitution, and Justice Oak has certainly upheld this duty. You could see that he enjoyed being a judge, not to wield power, but to dispense justice. He has protected individual freedoms and been a champion of the environment. Now, Justice Oak has inspired two members of the bar to write some poetry. Now, let me assure you that these two short poems which I am going to read out, they are not mine. They are also not by the two usual suspects who read poems when judges retire in the Supreme Court. The first is by a younger lawyer, Saurabh Suman Sinha. This is not, of course, in the mellifluous Urdu of Ejaz Maqbool. It's in prosaic English. There are those who were serious and those who were fun, and there are those who will be remembered for what they have done. You were courteous, you were clear, you are what they call without favor or fear. You were firm, you were kind, and that's the legacy you leave behind. And the second is a slightly wicked poem by Nitya Ramakrishnan, which we hope will make Justice Oak smile more now that he's not on the bench. And this poem goes, "The sturdy oak, not a tender sapling, may yet surprise you, all wit and sparkling." Thank you.
In this 16th Tarkunde Memorial Lecture, we are making a departure. Generally, the presidential address used to be given by our president, but this time he issued a diktat to you that after the main speaker who is delivering the lecture, there should be no other speaker. So therefore, I now invite our president, Mr. Lokur, to address the gathering.
Yeah, thank you, Ijaz. Good evening, Justice Abhay Oak, colleagues and friends of the Tarkunde Memorial Foundation, ladies and gentlemen. On behalf of the Tarkunde Memorial Foundation, I welcome you to the 16th VM Tarkunde Memorial Lecture. There are very few memorial lectures that have survived for so long. While cherishing the memory of those we respect and admire, we tend to forget the message they have conveyed during their lifetime. The Tarkunde Memorial Foundation believes that the messages, and there were many of them, conveyed by Mr. Tarkunde were, in a sense, eternal. Through his personal life, his writings, and his speeches, he conveyed a message of hope that even grim situations could be successfully overcome. His efforts during the emergency years gave relief and hope to many facing preventive detention. He came to be known and respected as a civil rights activist, particularly due to his close association with Jayaprakash Narayan, and as Raju informed you, he was the driving force behind movements such as the Citizens for Democracy and People's Union for Civil Liberties. His contribution in this regard has been immense, but I will not say anything more on this. Because what is of greater importance from today's perspective is to acknowledge and recognize Mr. Tarkunde's commitment to radical humanism and rationalist thinking. And the subject of today's lecture fits in perfectly with Mr. Tarkunde's philosophy. The topic of the memorial lecture is our Constitution and the fundamental duty to develop a scientific temper. While we must focus on preserving and protecting our rights, we must not forget our fundamental duties mentioned in Part 4A of the Constitution. We have in our midst an eminent jurist in Justice Abhay Oak who reminds us of our fundamental duty to develop a scientific temper and exemplifies the spirit of rationalism, the core of Mr. Tarkunde's values. In keeping with the idea of scientific temper, Mr. Tarkunde cherished the thought of a Renaissance movement in India to eradicate blind faith, orthodoxy, and superstition. In a lecture titled 20th Century Renaissance, delivered by him in Amsterdam way back in 1974, he referred to the cultural revolution brought about by the Renaissance movement in Europe. Referring to India, he added, and I quote, "There was indeed an analogous movement in India in the latter half of the last century, but it was soon overwhelmed by revivalist nationalism. In consequence, the bulk of the people continued to remain under the influence of religious orthodoxy, fatalism, and blind faith, and the humanist spirit of rationalism and self-reliance was confined to a narrow minority. In such a situation, democratic institutions which were introduced on the attainment of national independence were found to remain weak and unstable." I dare say the weakness and instability of our democratic institutions were exploited a year later when internal emergency was declared in our country. Mr. Tarkunde was the editor and later emeritus editor of The Radical Humanist, a monthly journal devoted to the development of the Renaissance movement and for promotion of human rights, scientific temper, rational thinking, and a humanist point of life. I have no doubt that the subject of the memorial lecture by Justice Abhay Oak would have gladdened Mr. Tarkunde's heart, who ceaselessly advocated a scientific temper in more ways than one. With these few words, may I invite you, sir, to deliver the 16th VM Tarkunde Memorial Lecture.
Good evening, my esteemed colleague, Justice Ujjal Bhuyan, Justice Madan Lokur, Mr. Raju Ramchandran, retired judges of the Supreme Court of India, retired judges of the High Court, senior advocates and ladies and gentlemen. It's a matter of great honor for me to deliver a lecture, 16th VM Tarkunde Memorial Lecture, organized by Tarkunde Memorial Foundation. Unfortunately, I had no occasion even to meet Justice Tarkunde, who was affectionately called in Pune as Bhau Sahib. As a law student, I was lucky to hear one of his great speeches in Mumbai. I don't recollect the occasion, but it was, I believe, a function organized by PUCL. I don't recollect what he said, but it was so inspiring. I was a law student. There were about 8 or 10 law students like me. After the lecture was over, all of us went to the volunteers there and we offered our services for PUCL. He inspired us so much by only one lecture. Though I did not meet him, I did not see him in action in court, I had privilege of working with and working against two of his illustrious juniors, M.A. Rane and C.R. Dalvi. In fact, Mr. M.A. Rane always used to tell all junior lawyers stories about Justice Tarkunde. He used to always tell us, Mr. Dalvi also, that unless you are 100% prepared, it was impossible to appear before Justice Tarkunde when you are judge of the Bombay High Court. Mr. Rane and Mr. Dalvi were very illustrious and respectable members of the appellate side bar in Bombay High Court. You know, there are two divisions there, appellate side and original side. Mr. Rane ensured that some junior lawyers like me, we pay subscription of Radical Humanist and we start reading that monthly issue of Radical Humanist. I continue to subscribe that. Maybe during last about 21 years, I was not reading in great detail. Now I have enough time to read it very carefully. But after interacting with Dalvi and Rane, I could realize what must be the mettle of Mr. Tarkunde. I want to say only two things about these two great lawyers from Bombay High Court, and I'm sure that they learned so much from Justice VM Tarkunde. I am saying this not because Madam Indira Jaisingh is here, but I am saying very important thing. Both Mr. Rane and Dalvi, along with two other very eminent lawyers practicing on the Bombay High Court appellate side, they refused to apply for designation because they were very firm on their conviction that designation must be conferred and never sought. C.R. Dalvi authored a very interesting article on Justice VM Tarkunde in Radical Humanist immediately after his death. He has mentioned something very important. He refers to those days of Tarkunde in Pune, and he has said that great Royists, great rationalists, people like Justice Tarkunde, Lakshman Shastri Joshi, H.R. Mahajani, G.D. Parikh, Dr. R.B. Karnik, A.B. Shah, G.R. Javin, of course Chitratai, all of them used to meet frequently in Pune, in Cafe Good Luck. That restaurant still is there at Deccan Gymkhana. Mr. Dalvi has said something very interesting about Justice Tarkunde. He said that he was the one, as a senior lawyer practicing on the appellate side of the Bombay High Court, for the first time started practice of paying reasonable amount to juniors. And till I became judge in 2003, that tradition of Justice Tarkunde was continued on the appellate side of the Bombay High Court. I don't know what is the situation today. In fact, Dalvi says in his article, it is only because a reasonable amount was paid to him by Mr. Tarkunde, the then senior lawyer, that he would survive in the profession. There is one work done by Justice Tarkunde which is actually forgotten by many. Probably Jayaprakash Narayan appointed him to head a committee to look into electoral reforms. And there is a report by Justice Tarkunde. This remarkable work, as I said, is almost forgotten. If you read this report, you'll understand his extraordinary vision. In 1975 or 76, when the report was published, he says that election commission should consist of 3 election commissioners, which happened in due course of time. Then he recommends that age should be brought down from 21 to 18, which was done by 61st Amendment in 1988. Then he was strong advocate of state funding of elections. His view was, if that is done, it will ensure free and fair election, and it will remove the influence of money. There was one very interesting suggestion by Justice Tarkunde. I don't know what happened to that suggestion. That suggestion was of forming voters' council at grassroots level, which will ensure free and fair election. So some sort of participation of voters at grassroots level to ensure that there are no malpractices in election. And of course, he said that the procedure for appointing election commissioner has to be very fair, which will ensure that he is free of any interference. I must say here why I volunteered to speak on the subject of scientific temper, because normally nobody speaks on this topic. Long time back, I had read a very old interview of Justice V.M. Tarkunde by one Fragel. I was so moved by that interview because he has given his strong views about religion. He describes himself as atheist. He criticizes Mahatma Ji for his views on religion. One answer given by Justice Tarkunde appealed to me, and I forever remembered it. I think question was put to him by Fragel about the falling standards of morality. And question was whether it can be attributed to religions in India. I'll quote only relevant part of his answer. What he says is, the remedy is not the recall of religion, but greater recourse to reason. Now this greater recourse to reason is something which I remembered forever. I read his writings. If you read his writings, he may not have used those words, scientific temper, but you can find that he has consistently batted for it. In fact, what he propagated through his writings and some of the speeches which I could read, the gist of what he said is in fact the foundation of Clause H of Article 51A. And that's why I decided to speak on this subject. What I felt was, speaking on this subject today, I can pay tribute to the great service rendered by Justice Tarkunde to the humanity. I have been part of legal fraternity for the last 42 years, 20 years as a lawyer and maybe 22 years as a judge. I have rarely seen on public platforms fundamental duties being discussed. Perhaps the reason is that Article 51A was brought on the Constitution by infamous 42nd Amendment during the dark days of emergency. Substantial part of 42nd Amendment was struck down by the Supreme Court or repealed by 44th Amendment by the subsequent government. But Article 51A, which forms part of Chapter 4A, was not touched. Those were the days when many felt that Article 51A, the fundamental duties, have been incorporated to diminish the importance of fundamental rights. We all students of law, we kept on reading commentaries of great H.M. Sirvai on constitutional law. In the third edition, which was I think published in 1983 or 84, you will find that H.M. Sirvai has dealt with Article 51A only in 17 or 18 lines. In fact, he says that newly inserted Article 51A or Chapter 4A is not a law. And most interestingly, he says that it is unnecessary to address Article 51A as it is innocuous. Of course, what Sirvai said was 41 years back, and much water has flown thereafter. We have progressed further. In my personal view, fundamental duties can be always read to support the fundamental rights. As some of my judgments may be wrong, even this view which I am canvassing can be wrong, but I'll try to make it good. I think in 2001, in the case of AII MS Students Union, the Supreme Court extensively dealt with Article 51A and even this clause H. In fact, Supreme Court says every citizen of India is fundamentally obligated to develop a scientific temper and humanism. He is fundamentally duty-bound to strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievements. And what is further is very important, the state is all citizens placed together, and hence, though Article 51A does not expressly cast any fundamental duty on the state, the fact remains that the duty of every citizen of India is collective duty of the state. So this was the status given to the chapter on fundamental duties, Article 51A. And I find this was reiterated in 2015 in that famous case of Charu Khurana versus Union of India, where Supreme Court says that it is clear as day that the duty of a citizen has been extended to the collective duty of the state. It is well known that precautionary principle, which developed nearly 15 years after Mr. H.M. Sirvai wrote his third edition, has evolved on conjoint reading of Articles 21, Article 48A and Clause G of Article 51A. As we know, under Clause G, it is a duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and to have compassion for living beings. Considering Clause G and collective duty of the state under Clause G of Article 51A, that it was held that the state is under a mandate to protect and improve the environment and safeguard forests. So, this concept of precautionary principle can be traced to this provision of Article 51A. And as all of us know, that Supreme Court said in view of Article 48A and Clause G of Article 51A, the precautionary principle requires government to anticipate, prevent, and remedy or eradicate the causes of environmental degradation, including taking stern action against violators. Why I am emphasizing on this, that this is one principle which evolved on the basis of Article 51A. So Article 51A becomes so important. Whether Supreme Court has departed from the precautionary principle is a matter of debate, which can be a topic on some other day. Though in 1984, Sirvai felt that Article 51A was innocuous, we have now realized that it plays a vital role in upholding fundamental rights guaranteed under the Constitution. For example, Clause A of Article 51A, it becomes not only duty of a citizen but collective duty of the state to uphold the Constitution and to respect the ideals under the Constitution. And how fundamental duty can complement fundamental right. We have freedom of speech and expression under Article 19(1)(a). It is the duty of the state and every individual to abide by the Constitution. So it becomes duty of every citizen to ensure that the fundamental right of freedom of speech and expression of other citizens is protected, and that becomes collective duty of the state. This is how we can read Article 51A. For example, right to lead dignified and meaningful life is now within the compass of Article 21. By virtue of Clause G read with Article 51A, it becomes a fundamental duty of every citizen to protect and preserve environment so that right of other citizens to enjoy fundamental right under Article 21 to live in pollution-free environment is protected. In this context, Clause H of Article 51A becomes very important. It casts duty on every citizen to develop scientific temper, humanism, and a spirit of inquiry and reform. Right to lead dignified life and meaningful life has been read into Article 21. I believe that we can lead a meaningful life only if we develop scientific temper. In absence of spirit of inquiry, which is covered by Clause H, science would not have developed at all. When we talk about duty to create scientific temper, it is a duty to develop new knowledge and new thought process. Even when the results of new thought process or new knowledge are not favorable or unfavorable to existing opinions and long-standing theories, we must develop new knowledge and new thought process. We must develop scientific thinking and scientific attitude, without which we can't develop scientific temper. Scientific temper naturally involves rational thinking. And that's what Justice Tarkunde told us. Rational thinking is so important, but now it is part of the scientific temper. In fact, having spirit of inquiry and reform is an essential part of developing scientific temper. Only if an individual does not accept anything without questioning or testing it on rational basis, it can be said that he has acquired a scientific temper. Unless we have integrity and courage to accept the data and results, even when they are inconvenient to popular beliefs, we cannot have scientific temper. In fact, a scientist is always in search of knowledge. Scientists always keep on asking themselves why. When we think of scientific temper, always issue of religion comes in. We have Article 25, which confers freedom of conscience and freedom to practice and propagate religion. Of course, Article 25 is subject to the other provisions of Part 3, including the fundamental rights. If any religious practice offends the right to live in pollution-free environment, it will not be protected by Article 25. Article 25 also permits and protects operation of any law made by a state, providing for social welfare and reforms. Therefore, if state legislates to abide by its collective duty to promote reforms, such a law cannot be hit by Article 25. Though our Constitution has existed for almost 76 years now, our society has generally not supported great people who have consistently promoted development of scientific temper and reforms. Unfortunately, in our society, anyone who proposes reforms in religious practices based on science or with the help of science gets targeted by people belonging to religious groups. This applies squarely to all religions. In a country like India, we desperately need scientific temper, as in our society, superstitions prevail. We do not understand the difference between faith and superstitions. The moment social reformers speak against superstitions, it is projected as if they are interfering with rights conferred by Article 25 of the Constitution. I believe that by performing your duty under Clause H of Article 51A, you do not do anything against the religion. When you fight superstitions, in religions or religious practices, you do not fight against the religion. You actually help the cause of religion. When we talk about scientific temper and spirit of reform, I must acknowledge, apart from Justice Tarkunde, the thoughts and work of great rationalist, Dr. Narendra Dabholkar. Throughout his life, he fought against superstitions in all religions. He led a very constructive and peaceful movement against superstitions. He went to villages, and by showing through experiments, he satisfied the villagers that ghosts do not exist. In fact, he has written that he went from one village to another where he found that this superstition was there about the existence of ghosts. So by performing simple experiments, he satisfied the masses that ghosts do not exist. By scientific methods, he tried to establish that the claim made by a few people that they can perform miracles was absolutely false. Very interestingly, as a part of his endeavor to develop scientific temper and to implore the others to develop scientific temper, he undertook scientific study of astrology, and he took help of a great scientist, Dr. Jayant Narayakar, who recently died. Not only Dr. Jayant Narayakar, but the Inter-University Center for Astronomy and Astrophysics in Pune and Statistics Department of Savitribai Phule University at Pune joined hands and conducted a study. After conducting study, a very scientific study, he felt that he has proved that astrology is not a science. Both Dr. Dabholkar and Dr. Narayakar have separately written in great detail about their experiment and why they have come to this conclusion. Though they were targeted and criticized, I have not read a single article or a single speech which methodically dealt with conclusions drawn by Dr. Jayant Narayakar and Dr. Narendra Dabholkar. Many of us know how life of Dr. Dabholkar ended and why this happened. Because he performed his fundamental duty under the Constitution of imploring citizens to develop a scientific temper and spirit of reform. In fact, that was his mission. When we say that we must develop scientific temper and a spirit of reform, we are not against any religion, as I said. And our society, we can see several instances of superstitions. I was reading a very interesting article. As all of us know, the first railway train ran from Boribandar, which is now Chhatrapati Shivaji Terminus, to Thane, which is my city where I was born and brought up. There were VIP guests, 400 in number, who traveled by that train. But later on, many people were superstitious. They felt that they should not undertake this journey by use of this machine or these engines. So there were quite a few who discouraged people from traveling by train. So that was a superstition in 1853. Unfortunately, though we have progressed in science and technology, we have rarely used science and technology to usher reforms in religion. Of course, there is one reform which I noticed, which is brought at least in one religion. And that reform is maybe with the object of saving the trees. The reform is that we establish electric and gas crematoriums. This is one very important reform which we brought about. Not that many people use this, but that's a reform we have brought about by using science. And we can imagine how much was the opposition in the beginning when some of the municipal corporations in Maharashtra decided to install these machines. The adoption of scientific temper will assure constructive reforms across all faiths. Somebody told me about a year back in one of the law schools. He said that we have been using, all religions have been using science and technology. And why you say that we lack scientific temper? He said that all instruments made by use of technology are being used by all religions. And we know that. We use technology. We use equipments which are in place due to advancement of science and technology in our religious festival. But we use it only to create noise, unbearable noise. We use it to create pollution of all sorts. Only because we use technology, it does not mean that we have scientific temper. Scientific temper is completely different. A person who doesn't know anything about science or technology, he can acquire scientific temper if he starts thinking rationally. In fact, if we had scientific temper, we won't use technology to create pollution during celebrating our festivals. Now let us discuss the effects of not abiding by the duty of developing scientific temper and spirit of reform. Science has shown that environmental damage not only affects the quality of human life, but also it harms health of human beings. We have rivers and lakes. While performing so-called religious ceremonies, we damage our rivers, seas and lakes, we pollute water. Article 25 protects right to worship or right to perform essential religious ceremonies. Since it is made subject to the other rights in Part 3, the act of damaging environment in the name of religion is not protected. We can avoid this only if we have scientific temper. Recently we had Kumbh Mela. Can anyone claim that it did not damage or pollute our rivers? Can we say that our rivers will remain holy with all the pollution which we have caused to the rivers? Not only one river, several rivers. But very few think on these lines, though it is duty of every citizen to do so. I'll give a recent example. I read in newspapers that there is a proposal to cut more than 1,000 trees, decades-old trees or 100-years-old trees, for holding Kumbh Mela in Nasik, which is to take place, I think, in 2027. Apart from the failure of individual citizens to develop scientific temper, why it happens? It happens because of the failure of the collective fundamental duty of the state to abide by Article 51. It is the duty of the state to conserve and protect the environment. It is duty of the state to ensure that scientific temper is developed. If that happens, no state will even think of damaging trees for the purpose of religious festivals. In fact, all this shows the failure of the state to perform duty to encourage people to adopt scientific temper. Superstitions prevail in all religions. Lack of scientific temper is not confined to only one religion. If we had perfectly performed our duty of developing scientific temper and spirit of reforms, we would not have allowed killing and sacrificing animals for celebrating religious festivals. We would not have allowed indiscriminate use of loudspeakers during our festivals. As we lack scientific temper, we who belong to all religions harm ourselves due to superstitions. As I said, it is collective duty of the state to comply, to perform duties under Article 51A. Immediately after India became independent, we established research institutions like Tata Institute of Fundamental Research, then Bhama Atomic Center, then of course ISRO, and many other institutions like Indian Institute of Technologies. Merely by establishing these institutions, which do work of scientific research and teaching in science, we cannot say that the state has fulfilled its collective duty to develop scientific temper. The political class, irrespective of parties, which rule us believe in appeasing religions, and therefore this class is completely unwilling to promote reforms. I can give so many examples where we have not corrected the tendency on the part of our citizens to believe in superstitions. And please analyze what state has done during last 75 years, the governments have done to ensure that our society becomes free of superstitions. Because the reason is that the moment you start talking about superstitions in our society and what is taught to us by science, the response is you are anti-religion, or because you are atheist and therefore you are saying all this. So all of us must remember one thing, that when we say that we need to develop scientific temper and spirit of reforms, we are not against any religion. In fact, we have progressed so much, the world has progressed so much in science and technology. If science and technology is used to bring about reforms in our religions, the religions will become more healthy, religions will become more progressive. But nobody is willing to do that. Now the question is how we can reform society and ensure that citizens fulfill their duty to develop scientific temper and spirit of reforms. After I admitted office, I had occasion to go and deliver lectures in schools and colleges. In one school, I asked teachers the question, very fundamental question, that how many hours we devote for teaching subject of civics. The answer was few hours in only one term. Then I asked one more question to some of the teachers. Are you telling the citizens, are you telling the students about their fundamental duty, and especially duty to protect the environment and duty to develop scientific temper? The answer was no. Now, if in our schools and colleges, we are not telling importance of fundamental duties and of course fundamental rights to our students, how do we expect that Article 51A and in particular Clause H will be implemented? Now, Article 51A was brought on the Constitution, I think on 3rd of January 1977. 48 years have gone by, but it has remained on paper. Unless we make this duty, fundamental duty, at least three duties. One, to abide by the Constitution and to respect the ideals. Second, to conserve and protect environment. And third, to develop scientific temper as part of our curriculum. We won't make any progress in this behalf. I go to many law schools and colleges. I have been doing that for the last 15 years. After question and answer session is over, I normally discuss this with the students. I found hardly any student is sensitized about fundamental duties. In fact, in one of the law schools which I attended function last year, one of the student got up and he said, "Sir, why you are telling us about fundamental duty? The moment you tell us about fundamental duty, we presume that you are against fundamental rights." Now, this is the misconception in the mind of students, law students, I am saying, from a very good law school. So, this is where I think we are going seriously wrong. When we come to the judgments of the High Court and Supreme Court, I don't think that this issue has been seriously raised. Though in 2001 judgment, Supreme Court refers to this clause H. I remember only few cases. One case was filed by a priest belonging to a particular religion. And his contention was there are a number of forms which citizens have to fill in for getting various reliefs from the local authorities or from the state. Now, in that form, you have to disclose what is your religion. So, he claimed that this is completely contrary to the ethos of our Constitution. And there he specifically relied upon clause H, and he said that no state can compel a citizen to disclose his religion or caste. He had relied upon clause H of Article 51A. But otherwise, we have very few judgments dealing with this duty to develop scientific temper. Even those who are associated with law have not realized the dangers associated with our failure to develop scientific temper. And therefore, we need reforms in our education system. We need reforms not only to incorporate the fundamental duties, but we must teach the students the values, ethos, and concepts of our Constitution. If you go to some law school, you will find preamble at the entry, but only having preamble at the entry and garlanding that preamble will not serve any purpose. We have to go further. As I said earlier, scientific temper helps us to lead a quality and meaningful life. In fact, I personally feel that developing scientific temper and spirit of reforms is a key to real progress. I am deliberately not using the word development, I am using the word progress. Because progress is something which is contemplated by under our Constitution, not the present idea of development. Where the moment you talk about present idea of development, you talk about infringing the fundamental rights, you talk about damaging the environment, you talk about damaging the fundamental rights, infringing the fundamental rights. So therefore, I say that this is the key to real success. Justice Tarkunde was a great nationalist who believed in humanism. Though that's not the subject, but clause H also refers to humanism. Now, where does humanism exist 75 years of Constitution? We have to find out from magnifying glass. We have to also ascertain whether anybody has understood the meaning of humanism. Because with the passage of time, we don't read what great people like Justice Tarkunde said and wrote. And therefore, we have forgotten the concept of humanism. If you read clause H again, humanism, scientific temper, and spirit of reforms, they go together. Because there cannot be any concept of humanism unless there is a spirit of reform. And there can be humanism only if we develop scientific temper and rational thinking. I believe that only remembering Justice Tarkunde is not enough. We must carry forward the mission of this great humanist. In fact, that is the need of the hour today. Where do we get such humanists today? I don't find anybody around, a great person like Justice Tarkunde. Therefore, we should take a pledge to carry forward his mission. I am really grateful to the organizers for giving me this opportunity to speak on this important topic. And I close by paying my respects to Justice Tarkunde. Thank you.
I received a complaint from the audience that only Mr. Ramachandran's thinking head and his hairstyle is visible because of the bouquet in front of him. Let me share a very interesting anecdote. Our 14th Tarkunde Memorial Lecture was delivered by Honorable the former Chief Justice Justice D.Y. Chandrachud. We started our practice together. So on the day of his retirement, I sent him a couplet, which was not applicable much to him, but it fully applies to my only senior, Mr. Ryan Karanjawala, and our president, Justice Lokur. And the couplet was, लहजे को ज़रा देख, जवां है कि नहीं है, बालों की सफ़ेदी को बुढ़ापा नहीं कहते. And when I narrated this couplet to Mr. Abhishek Manu Singhvi, who has the same hairstyle like Mr. Raju Ramachandran, he said that, then I said, let me edit this couplet, but its rhyme and all will get broken, so don't blame me for that. And then I narrated it again, that लहजे को ज़रा देख, जवां है कि नहीं है, बालों की सफ़ेदी या बालों के नहीं होने को बुढ़ापा नहीं कहते. Thank you, Justice Oak, for giving such a wonderful lecture today. I think he deserves a standing ovation from all of us. Thank you so much. I now request our president to give a memento on behalf of our foundation to Justice Oak. I will now request Mrs. Manik Karanjawala, our secretary, to present a shawl to Justice Oak. I will now request Mrs. Niharika Karanjawala to propose a vote of thanks.
Justice Oak, Justice Lokur, Mr. Ramachandran, honorable judges, distinguished seniors, and my friends, thank you for joining us today in remembrance of the life and principles of my grandfather, Justice V.M. Tarkunde. Justice Oak has always been known for his integrity and commitment to upholding justice and the Constitution. I believe he declared on his final day on the bench, "I always believed that a judge has to be very firm, a judge has to be very strict, and a judge should not hesitate to offend anyone. But I was harsh only for one reason. I wanted to uphold the principles laid down by our Constitution." When he chose the topic for today's lecture, we knew immediately that it would be not only inspirational, but also deeply thought-provoking about a subject which is not only so important for us all today, but was also of great importance to Justice Tarkunde. We thank Bar and Bench and LiveLaw for live streaming this lecture so that its impact may spread beyond this room. And on a personal note, I would like to thank all my seniors in the Tarkunde Memorial Committee who worked tirelessly, regardless of busy schedules and ill health, to make this lecture a success and keep my grandfather's memory alive. Most of all, thank you so much to all our distinguished audience for making time to join us today.